Thank you. Thank you very much, Advocate Mpofu, for the kind words. I'm not too sure whether I will be able to share my screen. Please do indicate whether you are able to see the screen. Are you in a position
We can
to
see you, Judge.
the screen as well? Are you able to see the screen as well?
At this stage, on my side, I'm only seeing you. I'm not seeing your screen yet. I'm only seeing you.
Let me see whether I can be able to share my screen. Gee, now this may be a challenge. I don't know. It asked me for anyone with a link can view. So which link? Otherwise, what I could do is to maybe email the slides to any one of you who's able to share. Is it possible? Can you hear me?
We can hear you, Judge. Let me just see if any of my colleagues is in a position to assist.
Yes, I could
Also
email the slides to that person so that it can be shared on the screen.
Judge, there's an email that I just shared on the comment section. If you can just use that email.
Okay, on the chat group. Let me just do this. Easier if I don't seem to see the email. Oh, yes, I've got it. Let me just... Yeah, if you can just bear with me. emailing the slides. You will tell me if you have received it. Have you received the email? Have you received it? Doesn't look like. Have you received it?
Judge, which email did you use between the two that were shared?
The Vumbi at situla@tennis.co.za.
Okay, because I it hasn't gotten to me on my side. Perhaps if we can also use the second one that we shared, that's just below it.
Okay, let me just see where it is. Is it ANA? Let's see, ANA CA MIC. Right. I've just emailed the other one. Are you?
Judge, they are checking. They'll confirm shortly.
Okay, all right. Oh yeah, it looks like.
I've just shared it, Judge. Are you able
Oh
to
yes,
access?
yes. Thank you very much, Mr. Muvumbi. I am certain that everybody else is able to access the slides that I shared on the screen. I've already been introduced. My role today is simply to share with you and at the same time learn from you the issue of constructive dismissal. And perhaps before I start, I should just ask the question that may be answered later, whether did anyone find in the Labor Relations Act the word or phrase constructive dismissal? I have been practicing in the labor code for many years, and I believe that I had read the Labor Relations Act a number of times. I do not come across the word constructive dismissal. So clearly, the question that we should ask ourselves is, where does this term, constructive dismissal, emanate from? Oh, by the way, I can't control the slides. Can somebody move to that second slide? Yes. Right, now that we on the second slide, the second slide tells us the origins of the notion of constructive dismissal. And it states that the notion of constructive dismissal has its origin from English law as far back as 1887. English law, as we know, is South Africa's law, South African law's common law ancestor. Now, those of you who have studied the history of South African law would know that we do have the English law and the Roman Dutch law as part of our common law. Now, in the UK, or in English law, the concept of the law of unfair dismissal was enacted in Britain by the Industrial Relations I see the asking that the slides be zoomed. I don't know if you're able to. Please assist the attendees in that regard. On the first slide that we are busy with it, they will give you an indication whether they are satisfied with the level of zooming. As you're trying to adjust it, and I take it that at the end of this webinar, you will be provided with the copies of the slides for your own benefit. Now, as I indicated, the law of unfair dismissal was enacted in the British law by the Industrial Relations Act of 1971. Now, one should then ask, when in South Africa did we start using the notion or the term constructive dismissal? It is a term or a notion that was imported from the English law, as I said, in 1986 in the matter of Small and Others versus Nuella Creations, Pty Limited. In that case, employees of the respondent resigned because the respondent contractually stipulated that stock unaccounted for would have to be paid for by the employees. Having resigned, then the employees were reinstated in terms of Section 43 of the then Labor Relations Act of 1956. Now, since then, the concept of constructive dismissal became part of South Africa's unfair dismissal law. The 1956 Act encapsulated every unfairness under the so-called unfair labor practice concept. For an example, as an employee who resigns and managed to show the elements of constructive dismissal in terms of, as I indicated, the English law, then that dismissal became what was known then as the unfair labor practice, either in terms of Section 43 or Section 46(9) of the Act, that is the 1956 Act. Right, we can move to the next slide. Right, as the slide is being sorted out for the screen, the slide deals with now the Labor Relations Act of 1995. That is the current act that is being used in South African employment law. We all know that this act is an offshoot of Section 23 of the Constitution of the Republic of South Africa. What is more important, that also briefly addresses the question I raised at the beginning of this presentation. The Labor Relations Act took it upon itself to create a statutory recognition of the concept of constructive dismissal. We know that Section 186(1)(e) of the Labor Relations Act somewhat introduced the concept of constructive dismissal. The Act or the section defines the termination of a contract of employment by an employee with or without notice as a result of the employer who made the continued employment intolerable for the employee. That, in terms of the Act, then becomes a dismissal. Then we can move to the next slide. The Act somewhat introduced what may be termed employer-induced termination of the employment contract by the employee. In other words, the employee would terminate employment, but not that the employee would want or voluntarily or freely terminates employment, but will terminate the employment because the employer had made continued employment intolerable. Even if the termination is from the hand of the employee, it becomes imputed in terms of the Act onto the employer. Then, in terms of the LRA, that employer, under those circumstances, would have dismissed the employee. The Act protects the employee against such situation in that although it is the employee who terminates the contract, the actions of the employer, if found to have unjustifiably induced such a termination, are found to be legally reprehensible. Let's move to the next slide. Most of you would have come across this decision of the Supreme Court of Appeal in the Murray versus the Minister of Defense. This decision is important because it somewhat sets out what constructive dismissal means in employment law. The Leonard Cameron, J.A., as he then was, aptly noted that in employment law, constructive dismissal represents a victory for substance over form. Its essence is that although the employee resigns, the causal responsibility for the termination of service is recognized as the employer's unacceptable conduct, and the latter therefore remains responsible for the consequences. Like I mentioned earlier, that it is the hand of the employee that activates the dismissal, but that dismissal is induced by the conduct of the employer. It is for that reason that the learned judge indicated that the employer would then bear the consequences of that dismissal. Although the Labor Relations Act does not tell us about constructive dismissal, but we know that for many years, since the concept was adopted from the English law, that form of termination that is induced by the employer, we then called it constructive dismissal. The Labor Appeal Court in Solid Doors, PTY Ltd versus Commissioner Theron and others, listed the following as the requirements of that constructive dismissal. And for our purposes, I would say that the Labor Appeal Court was setting out the requirements of Section 186(1)(e) dismissal. It says, 1, the employee must have terminated the contract of employment. Now, practically, all it means is the employee must write a letter of termination or verbalize to the employer that he or she is no longer wanting to continue with the employment contract. And the reason, you will see later on as we continue the discussion, the reason for the termination must be that continued employment has become intolerable. You will later see that intolerability is actually the backbone of a constructive dismissal claim. The employer made continued employment intolerable. Now, it's very important that we distinguish between an employer and any other person. And in this instance, I will give an example. A client of an employer may make employment intolerable for an employee. But because it's not the conduct of the employer, unless vicariously the employer is liable, then that will not meet this third requirement. Most importantly, all these requirements must be present to establish a claim of constructive dismissal. Let's move to another slide. Now let's consider for a moment all these requirements and see how do we better our understanding of these requirements. The old case of the Fijian of the then Appellate Division, now the Supreme Court of Appeal, indicated that the employee must evince a clear and unambiguous intention not to go on with the contract of employment, either by words or conduct that would lead a reasonable person, in this case the employer, to believe that the employee harbored such an intention. As set out in this Fijian case is important because there will be instances where there is no clear intention that is unambiguous for an employee to terminate the contract. In such an instance, then the first requirements will have difficulties. Then secondly, a contract must be in existence for this unambiguous intention not to continue with the employment contract to be evinced. Now, there are instances where you would find that the employee is on a fixed term contract, and the fixed term contract is ended by effluxion of time. And because the employment is terminated by effluxion of time, there is no longer a contract of employment. And therefore, the question would be, if an employee who has been left to continue in employment, even under the circumstances where the contract has been rendered or has expired due to time, what contract would the employee be terminating when there is a termination for the purposes of constructive dismissal? Now, that is why it's important that the contract must exist. An employee cannot claim to have been constructively dismissed if the contract of employment has already been terminated, unless the employee resigned on notice, but the employer dismisses them during their notice period. Notice period is a lifespan of a contract that both the employer and the employee gives to a contract that is about to terminate. Now, during that period, a contract still exists. The SALT staff, on behalf of ZNO and Metro Rail, the employee was dismissed during his notice period following his resignation. Now, because the period of the notice period was still in existence, that is why the employee was able to launch or lodge a constructive dismissal claim. We can move to another slide. There is a concept which is being dubbed here a legal nonsense, where an employee cannot claim to have been constructively dismissed and dismissed by the employer in the conventional sense. The two claims are mutually exclusive. Here is an example. An employee is charged with acts of misconduct. He doesn't attend the disciplinary inquiry, and then the employer dismisses him or her as a result of the misconduct. And before or when the decision to dismiss him is communicated to him, he then files a letter of resignation, seeking to say that the employer has subjected him to, or her, to intolerable conditions. So in that sense, once the employer dismisses the employee, that's the end of the contract of employment, and the employee cannot attempt to terminate the same contract. Resignation ought to be differentiated from abandonment by employees of their contractual obligation. Hence, if we go back to FIJN, it says that the resignation must be clear and unambiguous. Now, there are certain instances that may be confused with resignation, where an employee will simply abandon his or her work. Now, in those or under those circumstances, an employer has an election to, one, accept the employee's breach, because the employee who abandons the contractual obligations is said to be repudiating the contract of employment. Now, in contract law, once there is a repudiation or breach, the aggrieved person, in this instance, the employer, would have to make an election. The election is either to accept the breach and sue for damages, which cancellation, of course, could be a dismissal within the meaning of Section 186, 1A, or hold the employee to their contract and sue for specific performance. So an employee who abandons their employment can claim constructive dismissal if they can prove that they had resolved as employees to abandon the contract of employment and not the employer. Now, this is where the technicality in FIJN would come in, that it is unambiguous. This employee does not want to proceed with the employment contract. Now we can move to the next slide. I see there's a question, probably, maybe, I don't know, given the arrangements, perhaps the Q&A will come at the end. I will deal with all the questions, if possible, at the end of this presentation. I've actually given more time in my presentation for Q&A, as you can see, that I might be almost close to completing the presentation. But nevertheless, if it is accepted, I'll deal with the questions at the end. Now, here is the biggest part of a constructive dismissal. When I saw the invitation, and I then picked up that there is a question of nuances of constructive dismissal. I understood it very well that a constructive dismissal doesn't just become a constructive dismissal because a name of it had been called out. It ought to be proven. Now, the test for intolerability is objective. And perhaps at this point in time, I must just touch a little bit on the aspect that if an employee takes a view that he's been subjected to a particular conduct which is intolerable, that is the subjective view of the employee. But it doesn't end there. When the employee wants to sue for constructive dismissal, that subjective view must be tested on the objective basis. The heat exchangers case, the labor code stated the following: in my view, intolerability is far more than just a difficult, unpleasant, or stressful working environment or employment conditions, or for that matter, an obnoxious, rude, and uncompromising superior who may treat employees badly. Whether the employer's conduct, considered as a whole, together with its cumulative impact, is such that when reasonably and sensibly judged, an employee could not be expected to put up with it. In other words, no reasonable employee could be expected to tolerate or put up with the conduct. Now, with all this explanation that has been set out in that case, already one sees a difficulty where it will be required of the employee to demonstrate that even Joe Soap, who is an employee, a bystander, would not have tolerated this kind of conduct. Of course, one can tease this question: what kind of conduct would qualify? The court there indicated that you look at the circumstances and judge the conduct sensibly in consideration of all the circumstances. Now, at the end of the day, it will be the question of evidence more than anything else. Now, the Constitutional Court had an opportunity to say something regarding Section 186(1)(e). There has been a view that has been held consistently that before you can resign, you must have done everything else, and the resignation must be a measure of last resort. Now, clearly, the Constitutional Court, being aware of employees' rights to fair labor practice, once they exist, you don't have to wait that long in order to be given those rights. Now, the notion of last resort as denoting intolerability was debunked by the Constitutional Court. All that must be shown is that the actual existence of the intolerable conduct by the employer caused the resignation. Now, the causal link is important. We can move to another slide. Now, the third requirement of the employer having caused the intolerability. I did mention earlier that there must be a causal nexus between the termination and the conduct of the employer. Now, this is where, at times, where an employee delays in acting, given a particular conduct, it may be said that the intolerability was not the cause for the termination. Those of you who are dealing with delictual claims would know this concept of but for. But for the employer's conduct, the employee would not have terminated the contract of employment. The employee has to resign within a reasonable time of the trigger, which may be a once-off outrage or the last straw following the earlier string of events. This is important because at the time of evidence, there could be issues that certain conduct became obsolete over time. I can give you an example. An employee decides that I'm unhappy with the employer not giving me transport to attend a seminar. That's the subjective view of the employee. But whether another employee would find it unacceptable, that's when the objectivity test applies. But after that event, the employee doesn't resign, then another event comes in where he is not provided with transportation to go and visit maybe his sick parent. Now, those two events, they may somewhat be linked to the issue of the transport, but one of them may become obsolete in time and it might not be used as a trigger. Now we're going back to that you must resign within reasonable time of the trigger. There's a case of Agricultural Research Council versus Ramashwana, and you will, when you find time, read that decision. We can proceed. Now, here is the most important aspect, the onus of proof. You should know, or probably you would go and read Section 192 of the Labor Relations Act, where it says that in any proceedings of unfair dismissal, an employee must establish the existence of a dismissal. Now, if you are unable to prove a dismissal as an employee, you must fail. You don't make it from the starting blocks. Now, constructive dismissal, as it is now known, is nothing but another form of dismissal. Section 186 tells us what a dismissal is, and the so-called constructive dismissal is one of those forms of dismissal. Now, you have to prove. Now, the onus to prove the presence of all the requirements that we have spoken about rests solely on the employee. Once constructive dismissal has been proven, in other words, what I'm effectively saying is that once dismissal in terms of section 186(1)(e) has been proven, section 192 to say 1 says, then the employer must justify the fairness of that dismissal. Thus, the establishment of a constructive dismissal claims entails a two-stage approach. Firstly, the employee to prove the constructive dismissal, i.e. existence of a dismissal in terms of section 186(1)(e). And once that is done, the employer has to prove that its conduct was not unfair. So, towards the end of the slide, I'm going to throw a curveball, but let's wait until then. We can move to the next slide. Now, I thought it is important that I should also say something with regard to a constructive dismissal claim that progresses to a review stage in the labor court. Either the employer being unhappy with the decision of the employer, of the arbitrator, or the employee also unhappy. Now, the review tests whether a resignation amounted to a constructive dismissal is not that one of reasonableness as in Sidumo. It is that of correctness. Now, correctness is going to the issue of jurisdiction. Where an employee fails to establish a dismissal, then the bargaining council or the CCMA would lack jurisdiction. But once the court is satisfied that the employee was constructively dismissed, i.e., we have now crossed the jurisdiction path. We are now in the path of the fairness of the conduct of the employer. There, usually the Sidumo test would apply because it's confined not to correctness, but to fairness. The question to be asked being whether the arbitrator's decision is capable of reasonable justification on all the material that was before the arbitrator. There are a lot of other permutations that are given to the Sidumo test, amongst others, whether the decision of the decision maker falls within the bands of reasonableness. All of this since the Battle-Star decision of the Constitutional Court. And again, this is a concept that was also borrowed from the English law, that the decision must be so unreasonable that no other decision maker would make it. I see another question. We'll deal with it at the end. Right, now we can move to another slide, which I assume would be the last slide. Now, I have named this slide jurisdictional quandaries. And I have pointed out earlier that there will be a curveball that will be thrown at the end. And perhaps in the Q&A, this mystery will be unraveled. Logic dictates that once dismissal in this category is shown to exist, an employer will have no justification for what it had itself not effected. What I mean is this. All the employer will dispute, mostly, is that I did not dismiss you, you resigned. And if the employer succeeds in showing that the employee has resigned, that's the end of the inquiry. But if the employer fails to show that the employee has resigned, then it is required, because we have a dismissal in our hands, then it is required for the employer to justify that dismissal. Clearly, as I speak of logic, I don't see an employer who was unaware that its conduct would lead to a termination of contract, would even justify such a termination. Now, in terms of section 191(5)(a)(2), the CCMA or the bargaining council attracts jurisdiction for constructive dismissals. Now, here comes the curveball. What happens when the employee alleges that the reason for constructive dismissal amounts to an automatically unfair dismissal? These are not rare occasions. They have come up for decision. An employee says, I was treated in this way by the employer because the employer was actually wanting to victimize me as a union member. That brings about section 187, which is automatically unfair dismissal. Now, the question is, should jurisdiction shift to the labor court? Because now the employee has raised the reason for the constructive dismissal to be automatically unfair, or should it be shared? In other words, the CCMA or council determines the question of the existence of a dismissal in a form of a constructive dismissal, and then the labor court considers the question of the reasons, which may amount to an automatically unfair dismissal. Perhaps the attendees would know and answer this question. Then I move on. It must be remembered that constructive dismissal is a form of dismissal, but not an unfair dismissal. It may sound very technical, but if you consider section 186(1), or rather the heading of section 186, it defines what a dismissal is. It does not define what an unfair dismissal is. A dismissal will become only unfair if it falls within the categories of 187 or 188, or fail to show the requirements in 188. Now, section 192(1) places a duty on an employee to establish a dismissal. A dismissal as an event, I would call it for now. I have been dismissed. It's an event. So constructive dismissal is a dismissal in terms of Section 186 as defined. Now, once an employee succeeds in showing a constructive, what we term a constructive dismissal, that employee only succeeded to show a dismissal and not an unfair dismissal. I continue. What happens if an employer demonstrates that the constructive dismissal is fair based on any of the recognized grounds, like Section 188(1) is explicit? If you prove misconduct, if you prove operational requirements and capacity, the dismissal is fair. And it cannot be said that constructive dismissal itself is an automatically unfair dismissal. Then Section 187 is, I say, similarly explicit. These are the curveballs. Let's go to the parting shot. These nuanced questions about constructive dismissal may require legislative reconstruction, but first, deconstruction is paramount. And that's what we attempted to do. Thank you all for allowing me to engage you on this topic. This may be an opportune time for question and answers. The organizers will give me a directive from there.
Ladies and gentlemen, we are going to take a few questions, and I would humbly request the Honorable Judge to maybe start off by addressing the questions that are already on the platform, the ones that are on the charts. I believe there's 2 now, and then if anyone else has a question, they will ask thereafter. Thank you.
All right. Can somebody put them up? I don't seem to even recall them, those questions. Maybe the first question, then I can deal with that. Where do I find those questions, by the way?
They are on the charts, Judge.
Oh, okay. Oh, I see.
If you can just click
Is
on
this the
charts
first
there.
one from, where do I find it? Let me see whether I'm able to. Which question 1, is that the one from Surprise Slako? Or
you may go up a bit.
Butter?
Yes, there's
Yes.
Begita Mbambata. You may start there going down.
Okay. Let me see the one of Begita Mbambata. It, as I read it, with an instance of serving notice, is the employee still required to serve notice when they resign? I'm asking this because if the employer made the working conditions intolerable, why would the employee be required to serve notice in intolerable conditions? That's a very important question. Generally, when the conditions are intolerable, it is expected, and I mentioned logic earlier, it is expected of the employee to take, if it's a man, his jacket and walk away. And if it's a lady, take the bag and walk away. And there is no need for that person to serve a notice period, because that person would be subjecting himself or herself to a perpetuation of the intolerable working conditions. Now, here's the issue about the notice period. most employment contracts, and including the Basic Conditions of Employment Act, it is expected of an employee who terminates a contract, as well as an employer who terminates the contract, to still give what is called a notice period. Now, that's a contractual obligation. And if an employee resigns without serving a notice period, there is a contractual claim that the employer may put. Sue the employee for damages. So in those instances, if the employee has resigned and the conditions are so intolerable, there is no need to serve the notice. The employer would still be entitled to sue for the damages that may arise as a result of failure to serve notice. However, serving notice in itself does not suggest that the situation or the conditions is less intolerable. The employee would be saying, I am going, but I know that I have some contractual obligation. I'm going to serve this period of notice, but I want to tell the employer that I'm leaving at the end of the notice period. And what makes me to leave is the intolerable working conditions. So an employee may not be non-suited for a claim of constructive dismissal once all those three elements are shown, simply because, yes, you served notice and therefore you were not faced with intolerable conditions. So that is not applicable. I hope that answers the first question. Then the second question from, this thing is now, okay. I took it too long now. I'm not sure whether it's complete. The one from Mr. Saku. Does the unilateral downgrading of duties and benefits meet the threshold of making the employment relationship, and to believe that intolerable? Let me see. Yeah, I want to believe that it is simply asking whether the unilateral downgrading of duties and benefits meet the threshold of making the relationship intolerable. Again, it's a matter of evidence. It's a matter of, when judged sensibly, is the conduct of an employer one that will make the employee to put up with? I mentioned at during the course of the presentation that there is a subjective view that will be held by the employee. I'm subjected to a downgrading of my benefits and duties. This is intolerable to me. That's the subjective view of the employee. But if that leads the employee to resign, then when you claim constructive dismissal, the standard that is going to be applied in considering whether downgrading of duties and benefits meet the threshold is that of reasonableness, is that of objective standard. Now, if objectively any other employee will not put up with the downgrading of duties, which generally it amounts to a breach of contract, to an unilateral change of terms and conditions of employment, I don't think any reasonable employee would put up with those type of conduct. And that immediately is written all over it, intolerability. Right, those are the two questions that I'm able to see. Let me see, there's another. I'm not sure. Okay, it would have been, I don't know whether
Judge,
yes.
Just a moment, Judge. I see Mbata made a comment
Yes.
there. Maybe you can also deal with it, where he says,
Yes, I
I
see
would
it
have
as a
dealt
comment.
with it. Thank you.
I see Mbata says, I would have dealt with it as an unfair labor practice. I'm not sure whether what is it that would have been dealt with as an unfair labor practice. But perhaps this is in relation to the question that I had asked at the very beginning, that where do you see constructive dismissal in the LRA? You will find it nowhere. Now, an unfair labor practice, and I know that there are current amendments that are being considered to expand the meaning of unfair labor practice, because at the moment is very limited. But an unfair labor practice in terms of Section 186(2) is a particular conduct of an employer. And it is one that where an employee is subjected to. An employee may find it intolerable conduct. An employee may decide to terminate employment. And perhaps Mr. Mbata was actually commenting on the question of the unilateral downgrading of the duties and benefits. He is right. In terms of the unfair labor practice regime, that amounts to an unfair labor practice. So in other words, an employee may be put in a situation where, why did you not resort to an unfair labor practice regime before you could resign? Now, in other words, it simply says a reasonable employee would not have resigned. A reasonable employee would have referred a dispute to the CCMA and claim unfair labor practice. So that somehow correctly answers the question raised by Mr. Sako. Unilateral downgrading of duties and benefits may also amount to an unfair labor practice. How does one deal with an unfair labor practice? The Labor Relations Act has provided remedies. So you don't jump into a dismissal, or constructive dismissal as we call it, without exhausting the remedies that are provided for by the LRA. Now let's move to, okay, Mr. Bareng Mukwena. He's asked, in light of the decision of the LAC in Standard Bank versus Chilwani, if an employee resigns with immediate effect with an intention to lodge a constructive dismissal, can an employer simply, rightfully or vindictively defeat the intentions of the employee lodging a constructive dismissal dispute by simply charging the employee before the expiry of the notice period? Does that then mean, in certain instances, constructive dismissal is dependent on how the employer reacts? The answer to this question, the Standard Bank versus Chilwani case dealt largely with the residual power, contractual power that the employer has. I also penned a judgment in Mtimkulu versus the Standard Bank, where an employee who had faced disciplinary steps, the disciplinary procedures were completed and about to be given a sanction, the employee then resigned. And then Standard Bank said, hang on, you have a contractual obligation to serve your notice period. Come and serve your notice period. And then the employee wanted not to serve the period, and he was dismissed. And he then said that, sorry, Mr. Employer, you are too late. When you dismissed me, I had already resigned. I used the metaphor of soccer there. I said, Mr. Chilwani, or Mr. Mtimkulu in that matter, had actually issued himself a red card and said that he's the first man on the ball and he played the ball. That kind of a metaphor I used. But effectively, it goes to the contractual rights of the employer. Now, similarly, in the Chilwani, if an employee lodges a resignation which he would want to term constructive dismissal later, that doesn't stop the employer to say, we have a contract. You have to serve your notice period. I'm insisting. I can even go to court and insist that you serve your notice period. And of course, we know, as Mr. Mukwena would want to call it, vindictiveness, that the employer may say, yeah, now we have the opportunity to finish off a claim for a dismissal on our terms, not on the terms of the employee. Now, clearly, if an employee had a claim for constructive dismissal, the employee will still proceed. And I gather that at the hearing, the employer would agree that it has terminated the employment, but the employment was not terminated for the reasons as presented by the employee, but was terminated for other reasons involving conduct, capacity, and operational requirements. So constructive dismissal claim is not really dependent on how the employer reacts. It's an independent course of action that an employee is entitled to when faced with intolerability that leads to the termination of employment. So I hope that answers the question. Those are the questions that I see on the platform. I'm not sure whether there are further questions that had been raised.
Ladies and gentlemen, at this stage, if there's anyone who has a question, may we kindly tend to such questions. We will take 3 questions in consideration of the time. Thank you.
Yeah, I'll be guided, but I don't see if there's anyone raising a hand or anything of that sort. You will, yeah, that person will simply speak. I will probably see, or maybe the person must mention the name.
Indeed, Judge, I'm also monitoring. I will indicate should someone come up.
Okay.
Let's just give it maybe a minute or so. Thank you. Oh, there is another one by Surprise Tlago. Please check your chat, Judge, the most recent.
Oh,
question.
okay. Let me see. Or a municipal, do I take this one, or do you still afford? I see Barry Mukwena has a hand there. What must I do? Do I deal with this one and then thereafter deal with the hands? What do you
Yes.
suggest, Ms.
I would
Program
suggest that
Director?
I would suggest that you deal with the one in the chat, and then we
Okay.
take Baren's hand. Thank you.
All right. The question as I see it, a municipal whistleblower reports irregular expenditure and possible tender interference to the municipal manager and the auditor general. 2 weeks later, she's accused of breaking the chain of command and bringing the municipality into disrepute. She is suspended without a hearing and later dismissed, following an expedited, closed-door disciplinary process. The employer argues that the dismissal is unrelated to her disclosure and is instead based on gross insubordination and unauthorized communication of confidential information. The question is, how would you determine whether the dismissal is automatically unfair based on causation? Right, Mr. Saku, you, in your example, you are bringing to the fore two issues. Firstly, you are bringing the issue that is dealt with in terms of the Protected Disclosures Act. Now, briefly, in terms of that act, if an employee is suspended because that employee has made a disclosure that we call a protected disclosure, that amounts to what that act calls occupational detriment. Now, Section 3 of that act, that is the Protected Disclosure Act, then protects an employee. So such an employee may approach a court or even the CCMA and claim unfair labor practice by being subjected to an occupational detriment. That is the suspension itself. And if the employee is also dismissed for that reason, then that dismissal will become an automatically unfair dismissal. Now, on your question, you seem to be raising the issue of causation. Section 3 of the Protected Disclosure Act says that causation should be the basis that connects the occupational detriment that you are subjected to and the disclosure that you have made. Now, causation, it's a legal phrase, but it is constituted by two legs. Firstly, what we call factual causation and what we call legal causation. Factual causation is it fact that the employee was dismissed because of the whistleblowing? Once that has been established, then the next question is, which is the legal causation leg, would the employee have been dismissed nonetheless? Now, the dismissal would have arisen even in the circumstances where a disclosure had been made. So that's the leg of the legal causation. Now, if the court or the CCMA hearing a matter and one finds that there is factual causation, the dismissal is as a result of the whistleblowing, there is legal causation because Mr. So-and-so would not have been dismissed had he not whistleblown. And therefore, the charges of bringing the municipality into disrepute and breaking the chain of command would not be the cause of the dismissal. but the cause of the dismissal would be the disclosure. So that answers the question of how would dismissal automatically unfair determine the automatically unfair dismissal using the causation test. I have indicated earlier that there is what we call a but-for test. So had it not been for a disclosure, this person would not have been dismissed. This person would have not been dismissed, nevertheless. That's the legal causation. So I hope that answers the question. Perhaps we should go to the question of Mr. Mokoena, who is that Mr. or Miss, I'm not sure.
Good day, Judge, and good day, colleagues.
Yes, thank you, Mr. Mokoena.
It is Mr. Judge.
Or is it Mr.? Yeah, because the name barring, it can be
unisex,
of a girl.
Unisex.
Yes, yeah, it is.
Thank you, Judge. Judge, if I may be allowed, I see there were no other questions. That is why I thought maybe let me just clarify what I was trying to communicate with my question.
Okay. Yes.
So in instances wherein, let's say the employer created intolerable conditions, and I must say, I'm asking this being alive to the fact that constructive dismissal should not be a ticket to escape potential or looming disciplinary hearings.
Yes.
So supposed employer created intolerable conditions for the employee attempted to exhaust internal remedy, and there was no satisfactory address of whatever they are querying or they are complaining about. And then they tender their resignation. Maybe they allude in their resignation that I will be taking it forward in a form of constructive dismissal. An employer approach the Sentin lawyers. Most of them, they are the ones who are advising that employer, you must go all out to deal with the employees. So there they realize that, look, the only way to frustrate the employee is to charge them, because within the notice period, we can still charge them. And in the event that we charge them and the disciplinary hearing seats, either they attend or in their absentia, eventually they will be dismissed. And then when they go to the CCMA, there is a jurisdictional issue there in that you say constructive dismissal, but you left as a result of a disciplinary hearing. And the disciplinary hearing, the charges and all that doesn't really need to be merited. It could be just trammed up things, but will it not create a jurisdictional issue? That's basically what I'm trying to get clarity on. Thank you, Judge. I'll listen.
Thank you. I did at the end of the slide throw a curved ball. And the curved ball is about the jurisdiction of the CCMA and that of the Labor Court. But perhaps I should deal with the issue in two ways. Firstly, the question whether an employee has been dismissed or not dismissed, it's a question of jurisdiction of either the CCMA, bargaining council, including the Labor Court. Now, the situation that you have presented to me, it is one where the employer does not dismiss the employee for their own reason, be it misconduct, capacity, or operational requirements. But it is a situation where the employer would come up and say, Mr. Commissioner or Madam Commissioner, this person has resigned and we know why he resigned. Here are the charges that were supposed to be put against him or her. Then that questions the jurisdiction of the bargaining council on the basis that there is no dismissal at all. This person has just resigned, and because here are the charges, trumped up as they may be. But that's not the end of the road. The commissioner will still say, I have jurisdiction in terms of 191 to determine whether there was constructive dismissal. And for me to do it, once I hear all the evidence, then I can decide whether there is constructive dismissal or not. And those three elements shown to exist. And if none of those elements are shown to exist, then jurisdiction will fall away. But if all those instances are shown, then jurisdiction is shown to exist, then the employer perhaps will try and justify that dismissal using the trumped up charges. But that, even if it can appear to be, or it is astute for what you call the Santon lawyers, it doesn't prevent the CCMA commissioner or the bargaining council to inquire into whether there is a case for constructive dismissal, i.e. establish those three requirements. I hope that answers the question.
Judge, thank you for that. I am not seeing any other hand. Maybe we can take one last hand because we had indicated that we'll take 5. Let's just give it a moment and see.
Yeah.
Thank you.
I see, are there new questions on the platform? I see there's a Tamoledi Mabilu and Velemina Mloto.
Indeed, Judge, you may take Mabilo's question first, followed by Moloto's question. Thank you.
All right. Mabilo's question, as I see it, dealing with the test for constructive dismissal, especially when an employee resigns and claims constructive dismissal, that there is option of a remedy in a form of unfair labor practice. Does the alternative remedy serve as a valid defense to the employer? I need to clear something. I mentioned that intolerability is one of the elements that ought to be shown in a constructive dismissal claim. And some of the intolerable conduct may be conducts that constitute an unfair labor practice as defined in section 186(2). Now, an employer faced with a claim for constructive dismissal would firstly have to say, my conduct is not unfair. The employee is hypersensitive. No reasonable employee would resign for such a conduct. That's the defenses that the employer may raise. But if the employer picks up that actually you were complaining about the long leave benefits, the employer has a right to say that can't be intolerable because you could have used the rights in the LRA by launching an unfair labor practice. Now, if the commissioner or the panelist arbitrator upholds that issue, it does not follow that it serves as a valid defense to the employer. It can only say that no reasonable employee would have found that intolerable, because the reasonable employee would have attempted to exhaust the remedies which would have prevented an unfair early termination of employment. You would recall that the Constitutional Court case had said that intolerability doesn't mean last resort, because there were cases that suggested that now you must just put up and put up and put up until you are blue in your face. That's when we'll say, oh, now you're blue enough, you can go. So the Constitutional Court said, no, 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 that's not how it should be approached. But an employee may be criticized for not having taken steps to prevent resignation. In other words, the situation was not that intolerable that would lead any reasonable employee to resign. So the short answer is that it doesn't serve as a defense for the employer, but it may be used to criticize the intolerability aspect. Because being subjected to an unfair labor practice in itself is a conduct that is intolerable subjectively. But there could be questions that objectively, is it intolerable? Other employee may have gone to the CCMA, resolved it, and come back and continued with work. So that it should be seen in that context. Now I'm turning to the question of Mapula Velemina Mapula Moloto. It says, when an employee successfully demonstrates that they have exhausted all internal remedies, e.g., filed formal grievances regarding a work persistently hostile, hostile working environment, but the employer's inaction forced a resignation. The core challenge is evidentiary. Given that multiple colleagues are available but unwilling to testify due to a reasonable fear of reprisal, on what specific forms of objective documentation and what quality of circumstantial evidence does the employee's onus of proof fundamentally depend to meet the high standard of intolerability? Again, this question is more related to what the earlier question of Mabilu was. It's all about how do you prove the level of intolerability, applying, again, the objective test. It really doesn't depend on the the tricks that the employer may employ to delay, but it clearly depends on the evidence that, judged sensibly, can an employee be allowed to put up with that kind of a conduct? And again, you must know that exhausting all the internal remedies it's not a requirement. It may be used by the employer to say, but you were too quick in your actions, which the employee may rebut and say, look, I was faced with a persistently hostile working condition. I couldn't wait a minute longer. So that may count against the employee on on the aspect of evidence, but it doesn't mean that because the employee has failed to file a formal grievance, therefore, he has not been constructively dismissed. No. It is again on the standard, as you call it, the high standard of showing intolerability, the standard being objective. I see there is Proud Pofu. The question of Proud Mpofu, is that a question? No.
Judge, that'll be me.
Oh, yes, sorry.
I'm just indicating that we are thankful for all the questions. However, due to time constraints, we cannot take more, and that all the questions have been helpful, because we are also looking at the fact that we have gone above and beyond the time that you had initially allocated to us.
Yes. Thank you very much. I suppose that I've been of help to the people that wanted to know more about constructive dismissal. I've tried my best. It's always a very difficult subject, but I did my best, I suppose, even if this may sound like blowing my own horn.
You really did not have to blow your own horn. We are all singing your praises here, Judge.
Yeah.
This has been really eye-opening. We thank you. And at this point, I will hand over to our Deputy Chairperson, Advocate Christina Nokumulaudi, so that she can give her vote of thanks to you and to our guests and give us a closing. Thank you.
Thank you. I should remain on the platform as well. I shouldn't leave.
Indeed so, Judge. Please do remain on the platform.
Thank you.
Thank you very much. Thank you, our host, Advocate Mpofu. Good day, everyone. I am the DC of the organization, and it is a great pleasure and honor for me to welcome you all. FALA is, as a human rights organization, take pride in educating and building the practitioners wherever they found themselves in the area of practice, and also take note that at the center of our organization is humanity. I want to take the opportunity to thank the Honorable Judge, a Doctor of Law, Mr. Graham Mushwana, for gracing us with his presence and for sharing his expertise. We appreciate you, and we hope and we believe that you will accept our future invitations and have a fruitful journey with you together with us as the organization to building this Zanian movement together. I want to thank you, all the members, even the non-members of our movement, and say that we appreciate you, and it would be an honor if you can join us as well on our journey, because indeed this is a movement that is going forward and will be will be unstoppable in future, and making sure that we learn and we are guided as Azanian people, and in order to make sure that in our line of work we are all in order and we correctly so master our different fields. I thank you very much once more, Judge Mushwana, for the opportunity in gracing us with your presence. Thank you very much.
Thank you. I suppose that will close the session. I thank you all. Have a wonderful day further.
Thank you so much. This
Thank
will
you.
conclude this webinar.
Thank you very much. Keep well.
Thank you, everyone. Keep well.
Advocate Mpofu, may I just indicate that this session has been recorded and it's also on YouTube. Those that wish to rewatch can go back and watch it on our channel, Fearless Azanian Lawyers Association. Thank you.
Sorry, and before people leave, those who want the slide, please just comment your email on the comment section. Then I will make sure that I send them. I send the slide to everyone who needs it. Thank you.
Thank you very much, everyone who made time to be part of this webinar. And I hope next year, some of you who are not members will join the beautiful organization. Thank you.
Mr. Sitsula, I hope you are noting the email addresses. I don't know how long they will stay on the Zoom platform. I'm not very good with Zoom. If maybe we can just take a screenshot of those email addresses so that
Yes,
we don't leave out anyone.
That's what I'm trying to do before the platform cuts us out.
And also, if you don't get that email, you are free to contact any of us via inbox or whatever platform so that we can make sure that you do get a copy. We will also share a copy of the judgment that the judge was referring to, the one that he penned. I believe that it will help all of us because in any event, this is a learning curve and we also need to all assist each other going forward. Thank you. So, Mr. Stula, do you mind when you send the slides to also add that judgment that you shared with us in the group earlier, just so that people can be more enlightened? Thank you.
No, it's okay. I'll definitely do that.